Good morning and happy Saturday. My name is Meghan Maes, and this is Being Civil in Minnesota. This is a place I come every Saturday at 10 to talk about family law issues and issues impacting the district court system in the state of Minnesota. I am a licensed attorney. This is not intended to be legal advice, nor does this make me your attorney. I like to come here and give people free resources. So the group Being Civil in Minnesota is a place where you can go and ask questions anonymously, and I will come here Saturdays at 10 to answer those questions. We got some really great questions this week, and so I will get right to them. But before I do, I just want to say it's exciting downtown Mankato today. The Mankato Marathon, half marathon, 5K runners today. Good luck to everybody out there. I will actually be able to root from you from my office. So beautiful day for a race. All right, so the first question I was asked was about termination of parental rights. So a termination of parental rights is a process where a parent, here comes the sun, can have their rights to one of their children end, meaning it would stop. They would not have any further rights to that child. There are two kinds of terminations that can happen. One is a voluntary termination. That is where you would agree that a termination should happen or could happen by agreement. The other is an involuntary termination, and that can impact your rights to your future children. And so the question I got was regarding a termination of parental rights. So I'll go ahead and read it. So I ended up getting pregnant earlier this year. It was a big whoops, as me and my husband had our parental rights terminated and were not ready to even think about trying to move forward and start a new life when we needed to raise a baby, as we were still damaged from our other case. So we found someone who was going to adopt our baby. They signed something for custody stating that after the 72 hours they would fill out paperwork and give their rights to those children to a third party. They got a different lawyer. She's the biological mother, and her question is based on the fact that Child Protection Services went to the hospital and took the baby despite the legal paperwork that was submitted to the hospital from that other lawyer. The social worker was, according to this individual, rude, even though she stated the biological mom told the child protection worker that she was not trying to keep the baby. She felt that the social worker was blaming them for being upset. She wants to know, is she legally responsible for causing the adoptive parents mental distress? I know this sounds weird. She wants to know, is she a monster and caused the pain? And she wants to know if CPS had legal rights to take the baby away, even though her and her husband had the plan with the other family and their lawyer. They signed papers and all legal documents, or did Child Protection Services kidnap the child? Okay, so there's a lot there to unpack. First of all, if Child Protection Services is getting involved, it might be important to just kind of briefly kind of talk about what the child protection role and process is. So if there is a report of neglect or maltreatment of a child, the county does an investigation. And that at that point, the county will make a determination whether or not they believe maltreatment or neglect occurred and what the plan is moving forward. Typically, that would, if they're going to file paperwork, they would file something called a CHIPS petition, which is a child in need of protection services, alleging the specific grounds as to why they believe a termination or why they believe that the child is in need of protection. If the allegations are severe enough, there are ways that the county may move beyond just the petition to have the child be in need of protection, but they may move right to a termination. This anonymous poster didn't say whether or not they had their rights voluntarily or involuntarily terminated. I suspect because child protection automatically got involved that it may have been an involuntary termination. And an involuntary termination can impact your rights to future children. So once an investigation is done, once a petition is filed, then there's typically a case plan that is provided, which is sort of a path forward for parents to reunify with their children. The goal of the county in almost every case is reunification, and that is because they want to provide support and services to the family so that the child is no longer in need of protective services, but that the parent then would resume the role of the legal guardian for that child. The county has the burden of proof. If you do want to contest it, it has to be by clear and convincing evidence, which is a higher standard. And they would have to prove the grounds for termination and that they either attempted to reunify or reunification was not possible. There are certain circumstances where that step may not be at the forefront, again, if the allegations are of a certain kind. There are additional requirements for the county if the child is an enrolled member of a tribe or if they are eligible for tribal membership. This is because there is a rule called the Indian Child Welfare Act. And so there's a great fact sheet on lawhelpamend.org on terminating parental rights. I would suggest going there and getting further information. But back to the member's question. The county does have a right in subsequent cases to intervene if a parent's rights have been previously terminated. So I'm guessing that is why the county was involved. With regards to mental anguish or you being a monster, I can understand not wanting to involve the county, but certainly the county is going to get involved because that is the role. And based on the history of a previous termination, they come in and want to make sure that, number one, the kid is safe. And maybe this family is a great resource and will end up getting to adopt. That at this point, I think, would be between the county and those individuals. And adoption would require some form of background check. And so they can certainly look up some additional information on that. Okay, so the next question I got was about taxes. Yay. Not a tax attorney, but I know a little bit. So the question was in another group, somebody had asked if the IRS, the Internal Revenue Service, can trump a court order that requires the parties to alternate a child on their taxes when a child is with one parent almost exclusively, close to 100% of the time. The question is, can the parent doing all the caretaking ignore the order and go by the IRS standard? So the IRS standard is a child can be claimed as a dependent as a qualifying child if they have lived with you for more than half of the year, right? 365 days, that's an odd number. You should be able to calculate based on, overnights, which parent had the child more. And it normally doesn't come down to counting days. There's typically a very clear parent, unless you have an equal parenting time schedule. So only one parent can claim the child on their taxes at a time. And if you do claim a child in violation of a court order, there is a rule that says the other parent can come after you for attorney's fees, costs, and stuff. So you do not probably want to just ignore a court order. So if the court has already ordered you, that releases your claim under the IRS, unfortunately. So things that you can do to protect yourself, you can make that request that the alternating exemption be based on the other parent's fulfillment of their child support obligation. Are they up to date on their support? And if not, can they claim the child? And if they're not up to date and your agreement is based on that, then no, they would not be able to claim the child. If the court order does not say anything about exemptions, then the IRS rules would apply and it would default to the parent who has the child for more than 6 months out of the year. And so if that's going to be you, maybe you don't want to bring this up, because the default rule will give the exemption to the primary parent, which is typically a place where these exemptions and tax credits are most helpful to the children. And then very interestingly, if there is a parent that has less than 10, and I think this will answer the question, if a parent has less than 10% of the parenting time, that absent an agreement, the parent with less than 10% may not claim a child on their dependency as a dependent on their taxes. So don't agree if they are having less than 10% parenting time, that they can have the dependency exemption, and then they are prohibited under Minnesota law. So then we had a poll question, which was our very first poll question. And it was somebody messaged me and said, what would you do? So I created a poll, and here was the question. At the end of our last scheduling conference, the judge asked if we had each other's emails to communicate. It has not been ordered yet, to my knowledge, with regards to how we are supposed to communicate. The other parent does not ever check their email and wanted to know, or that other parent would know, that there had been several emails sent to them. The other parent texted for the first time since court, wanting to know how our child was doing. The question they asked is, should I respond? Should I text them back? Or email them back and ignore the text? What would you do? Based on our poll results, 41% said that they would text back, 58% said that they would email back, and 1% said, I wouldn't even bother responding, which I appreciate, because that was an option, and I'm very interested to know parents' candid responses. So what does this person have to do? Well, nothing, right? If you're not court ordered to communicate in a certain manner for certain information exchanges or requests, then you have to use your best judgment, right? And when you go into court, you always want to be the most reasonable person in the room. So it's better to agree on a method than have two competing methods. For some families, they don't even think about it. Sometimes they email, sometimes they text, sometimes they chat at soccer, right? I'm lucky enough that I don't have to have restrictions on my communication with my children's parent, right? Because we are not together. But if there were rules, I would follow the rules, right? And in this case, the judge had suggested email. I would maybe consider texting back and saying, hey, the judge indicated communication through email would be good, so I'm not going to respond in text anymore. Please check your email. And then you've done everything you can do, because sometimes there are reasons why you don't want that other parent to have access to you, and your phone is always here. And if you're experiencing safety concerns or experiencing feelings of being harassed by that other parent, this time they said they want to know how the other kid or how their child is doing, which is a completely mundane thing. In some cases, it can be used as a tactic to get to the other parent, to create a situation where they are in the same space, and then that other parent can try to woo or earn back or get back together with the other parent. And so in unsafe relationships, it takes sometimes more than 7 times on average to leave an abusive relationship. If we're forcing parties to come together in these unsafe exchanges, or putting them in situations where they can be love bombed and the cycle can continue. So we want to be really sure that the form of communication is going to enhance the safety and improve the lives of the parents. So if you want to set up a separate email and you say, I'm going to check it every 48 hours, and then you can prepare yourself to do it, that's a completely reasonable thing. There are also other apps out there for parental communication. There's Our Family Wizard. There's a cost for that, but there's a tone meter, which will not stop a parent from saying something jerkish. It will strongly suggest to them that maybe they want to check their tone. So it can be really helpful in improving people's communications. So thank you guys so much for stopping by. I am loving all the exciting outfits, and I'm going to go check out the marathon. So I hope you guys have a great rest of your Saturday. If you have questions, please post them in the comments, or you can post them on the group Being Civil in Minnesota anonymously if you would prefer to keep your secrets to yourself, but still get some help and information. So I thank you for stopping, and I will see you next Saturday. Bye.